I am Allison Conch, and I'm the program manager for Special Education Resolution Center. And I'm here with Joanne Blades, who is our former assistant director, most recently retired, who worked here at CERC and kind of ran our program for about 18 years. So today is our part 2 of the 3-part webinar series on due process. Hopefully you were able to join us for part 1, but if not, that is or will be soon archived, the recording on our website. So Joanne, I will be sharing my screen here in just a minute so we can get started.
Okay, great. While you're getting that screen up, I want to remind everybody that while I'm an attorney, I am retired from CERC, and I will just be talking about my impressions and things that I observed during my 18 years. I am not here to give you legal advice, but I can answer any questions at all. I know that parents filing due process are often pro se, which means they represent themselves. And the purpose of this webinar is really, the series of webinars is really to try to take the, make it not so mystical. We have rules, regulations, forms, but we wanted to just talk about it so you don't find it to be so confusing. After the last one, I got some feedback from some people and they said it was very, very legal. And I'm like, well, yeah, it's a legal proceeding. Anyway, this is the second webinar of our 3 series. And the first one dealt with getting ready to file and making your filing. And this one is, what are the activities before the actual hearing date? So next page, Allison. Okay, so to review over just basically from the filing, this is just a little bit of information to kind of set our context. The filing date, that's the date that you fill out your due process request. Complaint notice is what it's called, the due process complaint notice. You can use a form or you can use it in written form as long as certain information is on there. And that filing date is considered the date when both the school district and the State Department of Education receive it. So in webinar 1, you might review over that when it's available, because we do have information about filing the document. Okay, so the filing document, it's filed on a day. When we start counting timelines, we count that we start with the day after it was filed as number 1. So if it's filed on the 1st, you're going to go to the calendar and you're going to count, okay, 24 hours later, the next day is the 1st day, the 2nd day, the 3rd day. So it's really important that you know the filing day when you're looking at the timelines. Okay, Allison. When you file at the State Department of Education, the State Department is going to send all of that information to CERC. We have a contract with the State Department of Education and have for over 18 years. We manage the due process hearing process. We train the hearing officers, we assign them, we arrange for the program to be functional, to meet OSEP requirements. We did not design this program. This program is designed in federal law. We are monitored on it by the Office of Special Education Programs, and we have to do it exactly as we are directed by federal law. We could provide more in some areas, but we cannot provide less. So once CERC receives, the office receives that paperwork, they immediately contact the school district to make sure everyone's received it. So we know the State Department's received it. We want to make sure the school received it and when, and we count that as the date of filing. And then we assign a hearing officer. We are directed by OSEP to assign a hearing official on a rotational basis. The only time we don't is if you have filed another cause of action or another filing within a year, because we feel like that hearing officer already has information about the parties. And sometimes parents, for one reason or another, may withdraw or refile. So we assign it back to the original hearing officer. It'd be the same hearing officer that had your case before. Then after that is done, CERC processes a package of information that is actually mailed to everybody. I think it's mailed, it's sent by email, and it includes your due process rights under the law, a booklet called the Due Process Guidelines, which looks like this right now. And we send mediation information. We send information about the hearing officer, who it is. We send their vitae, their background, and other documents, so that if you believe there's a reason that the hearing officer could not make a fair decision, maybe there's something, maybe he's married to your uncle, I mean, I don't know, or she. So you would want to, have that information to make an informed decision about if you're okay with everything, to know a little bit about them.
And I will say, I know we mentioned this a little bit in the first webinar series. CERC will reach out to you if you have filed, not just by way of mail with the package of information, but typically a phone call as well, just to kind of try to inform you of our role, and clarify who we are and where we can and can't provide guidance to the parties.
Yeah, and CERC tries to be very consumer friendly. There's things we're not able to do, but we understand. I mean, it's a confusing process. It is a legal action. When you file due process, you have initiated a legal action. So on filing actions, when the CERC office does get that initial filing I talked about in the last slide, they count out about 30 days for the resolution time period, which is set in federal law, and about 12 more days into the hearing time frame. And then they give a range of dates, and the hearing officer actually selects and sets that date for hearing. We send that out to all the parties in that initial package. It's a letter that goes out. It says when we received it, when the parties, when the hearing officer has set the date for hearing. That date can change, but we want to inform everybody. We want people to know that you're keeping an eye on that hearing. You didn't just take an action of filing. You filed, but you're moving to, like, where are you going with all this? And we give them the date and then the hearing officer information. So you'll have that. Remember, I think in the last webinar we talked about, you can contact the hearing officer. You will have contact information, but you must always copy the other party to the due process. We allow no communication between one party and the hearing officer. As a parent, you wouldn't want the school district to have that communication with the school, with the hearing officer, and the parent wouldn't want the school having individual contact. So it's a rule. It's called no ex parte. It's a legal term, communications. So we set the date for hearing, and that date for hearing is not set in stone. It can be altered. Sometimes people say, oh, I can't absolutely do that. My daughter's getting married that day, or, something's happening. And we understand that date can be changed. We are under pretty strict guidelines for how far those dates can be changed, but that date for the hearing can change based on certain circumstances. You're going to hear about something called the resolution time period in the resolution session. So based on a change in the resolution time period, that date of hearing might change. If an amendment to the due process hearing is made, that date is going to change. And if someone requests an extension of time, that date will change.
Now, Joanne, are there specific things that are allowable or not allowable during, or if a parent or a party were to request an extension of time, there are certain things that can and cannot be considered? If it's
Yeah, when you file an action, don't think that you can just leave on vacation, because you're going to have actions that have to occur. So things have to happen when those are set. OSEP is very clear about that, because these cases are about children and they're about their education and about where they're at in life. And so we'll talk a little bit more about when that will be. as time goes by in these next films. And Allison, bring that up again because things are not coming right to my head. All right, so we have already talked in our first webinar about what types of due processes you can have. You can have a regular due process or an expedited due process. And we're going to talk about the timelines for both. So a regular due process, to remind you of what it is, it's over the 5 basic things. It's just the evaluation, placement, I can't remember off the top of my head, anything to do with the child's education in the school that relates to that IEP in the process. And the timelines for that resolution time period and the timelines I'm going to talk to you about can change. But in my mind, it gets really confusing if you try to remember every change because it may not apply to you. So I always think it's easier to think in terms of it as there's just 2 timelines. That when you file the due process, there is a resolution time period, and it lasts about 30 days. In a regular general, no actions happening, it's going to be about 30 days. It can shift shorter and it can shift longer, and I'll tell why in just a second. But at the end of those 30 days, then it's going to spring to life in a hearing timeline. And that hearing timeline, OSEP tries to keep as close to 45 days as possible. They really frown upon certain extensions, but we want to talk about how those timelines can shift. So during the resolution time period, think in your head 30 days because you file a due process complaint notice. And it basically means I'm giving you notice of what I believe you have done to violate the law and my child's rights. And I'm giving you 30 days, about 30 days to fix it. And if you don't fix it, then I am going to ask that go to hearing. It will spring to life in a hearing. So it's that 30 days and then 45 days. If you think of those 2 groups. Now it can shift shorter and it can shift longer, that 30 days. In the resolution time period, and I think I'll say this again in the next slide, but the 30 days can shift shorter. Let's say the parties filed the due process and both the parent and the school said, you know what? We don't even want to talk about this anymore. We've been negotiating this for 6 months. We already know our position. There's nothing else left to say. And I want to go straight to hearing. And both the parent and the school agree with that, then the hearing officer can begin the 45-day timeline. But they both have to say in writing, and they both have to agree to that. That's never happened in my 18 years. And I think it's because during that time, people are also preparing for hearing. And it's worth talking about it again. Maybe people will take it more seriously if you filed. Maybe circumstances have changed. You've upped the ante a little bit about what will happen if your issues are not resolved. Sometimes it just makes a difference. If you decide to waive the resolution session and go to hearing, that would shift the 30 days short to whenever you say, we're done, we want to move forward. It could shift longer if you chose mediation and couldn't get that mediation scheduled within the 30 days. OSEP allows for that 30 days to expand a little bit to allow for that mediation, but they don't want to see it expand for a long time because again, they're trying to keep these tight timelines to get some resolution for this child and the problems that are going on with them. The hearing timeline that starts and will last 45 days can shift longer if someone asks for an extension. An extension would be granted for good cause. The hearing officer will extend that. It could shift longer, say at the end of the hearing, if people want to get copies of the transcript so they can cite to the evidence in the transcript, they may ask for that 45 days to be expanded to allow for them to write a brief or to submit evidence, not evidence, but cite to evidence. They may need a little bit more time to do that. They can ask the hearing officer to extend it. A hearing officer cannot, under any circumstances, extend it by themselves. They must be asked to do it. They can't do it on their own. Okay. You know, a webinar and all of a sudden your nose starts itching. I don't know what it is. Okay, so in a regular due process, you have that resolution time period. And I know I'm repeating myself, but I know this is new and they say people don't understand it till you talk about it 3 times. So I don't mind. The purpose of that resolution time period, when the law was changed in 2004 to create it, my understanding is that a lot of people the schools had gone to the legislature and said, look, parents are filing and they will not even sit down with us. Sometimes we don't know what this hearing is about till we walk into the hearing. And we need a time to try to resolve this before we actually have to go. And so I guess the legislatures got together and thought, how are we going to fix this? So they thought about just making mediation mandatory. You must sit down in a mediation. But the mediation people across the country said, oh, no, mediation is supposed to be agreed to. Both parties have to agree to it. It can't be mandatory. So they thought, okay, well, let's do a resolution time period and we'll require what we call a resolution session. So in that 30 days, that general 30 days of the time period, the school district is required to set a resolution session to discuss the issues of the due process has to be held within 15 calendar days. And the due process cannot start until that session has been held. If a parent says, well, you've offered it on day 14, but we can't make that. We have an important doctor's appointment we've waited for 5 months. Could we do it 3 or 4 days later after 15 days? The school can agree to that. But if the parents don't meet at all during the resolution period, if they say, well, we filed this, but we're kind of scared to meet with everybody, they scare us in the meeting, then the school can go to the hearing officer and ask them to withdraw the complaint. So you're going to have to meet with the school. There's just not a question about it. Now we do, and you'll learn a little bit about this later, we will provide a neutral third facilitator, neutral third party that comes in and acts like a mediator and negotiates, help the people talk, pushes the sides a little bit and see to where they could come up with some settlement on the issues. Now, who goes to these resolution sessions? They're attended by parents and they're attended by relevant members of the IEP team and someone from the school with decision-making authority. And that's because it ends in an agreement that is signed and enforceable in court. So you have to have 2 people there that can sign, the parent and the school that has somebody that has decision-making authority that can sign a contract. Now, actually, the parents can choose who comes with them to the meeting. The parent is required to attend, but they could choose to have their attorney come. They could choose to have an advocate come. They could choose to have their pastor come. They can bring Santa Claus if they want to. The school gets to determine who the relevant members of the IEP team are, or anyone else that would be necessary for information, and at least somebody with decision-making authority. So the school decides that. If the parent chooses not to bring an attorney, the school district cannot bring their attorney. And we often see resolution sessions and resolution time periods used for resolution sessions when the parent has filed pro se and doesn't have an attorney. So they don't want to go into a meeting with the school attorney there. So we have been a system within the state that has a lot of resolution sessions because actually we have a lot of pro se parents. So the issues, if they are resolved, whatever issues are resolved or all of them are written into a document. It's a contract about what's going to happen, what the parties have agreed to. They will ask the parents often, if you've agreed to all of these things, are you willing to drop the due process? And they will ask them, and oftentimes parents will if everything's been agreed to. The thing is about a resolution session that's a little bit different from mediation is that the party, after they sign those resolution session agreements, they can rescind them, either the school or the parent, within 3 business days.
And Joanne, that's to give the parties opportunities to consult with others, right? So like, if the parent's not represented in the school, obviously can't have their attorney there. So if they consult with their attorney, or even if the parent has someone in their family that's an attorney or an advocate or someone that maybe couldn't be at the meeting because they could bring
Right,
whoever, and they
right,
wanted to consult with them and then change their mind. That's
right,
kind of the intent of those
right. Or
days,
maybe
correct?
the people felt pressured during that time. It's only happened one time that a party said they were going to rescind. And that in my 18 years, it only happened one time, and they ended up not rescinding. We try to make sure that the parties are really happy and they don't feel coerced. I kind of call it the Avon rule, where if you have somebody coming to your door to sell you a vacuum cleaner or Avon, you have 3 business days to change your mind about that order. And it's the same way with this. You get time to decide, I don't know what I was thinking. That was just crazy. Or someone to advise you, what were you thinking? You didn't think about this. But generally, the facilitators will try to make sure that it is the bases are covered, you've thought of everything, and we want to have an agreement that's solid, but you do have that 3 business day opt-out period. Good question, Allison. Okay, so the resolution session is mandatory. That's regs, and I've cited them there because I'm constantly going to ask you to read those regulations for the rules. The resolution session must be held before a due process hearing can be held. Must be. The attendance to that resolution session is mandatory. You must go unless you waive it. There's 2 ways to get out of going to the resolution session. When both parties agree to waive it and go straight to hearing. That's the instance where they say, we're done. We've been talking about this. There's nothing else to negotiate. Let's just get over this and go straight to hearing. But both parties have to agree. That has never happened in the 18 years that I was at CERC. And I think practically most parties are exploring what they could do to settle it. And also, it takes a long time to get prepared for the hearing. You have to be working during that resolution session time period to prepare for the hearing because it's not an easy thing to prepare for. The other way to get out of going to the resolution session, if both parties agree to do mediation instead. Now, mediation is a little bit different in that if the school district can bring their attorney to a mediation because the statute does not say they cannot. They might choose not to. They don't have to. They're not forced to bring them, but oftentimes that's what happens. Also, once you sign that mediation agreement, the contract on what's going to happen, it is enforceable at the moment of signature.
But otherwise, those 2 sessions, whether it's resolution or mediation, the purpose and the function in the context of the session is very much the same.
Very much to discuss the issues of the due process. It doesn't discuss anything outside of it. If you've decided that you had something else, a parent says, oh, well, there's something else I didn't like. It won't be discussed if it wasn't in the due process request. It's only for the due process in this situation. Okay, next slide. Okay, so for that resolution session, if a parent's going, and we do have parents that file and are scared to go. That's happened. It's not uncommon. And they have to go. I have to explain that. If you don't go, you could have if you just don't show up, you could have your case dismissed. The CERC office, though, we will provide a neutral third party. And they are not an advocate for either side. They are not an advocate for the school, and they are not an advocate for the parent. They do work with the parties to explore their positions, to help them articulate their positions and get it out, what they're seeking, what they're trying to resolve, and to work with the parties to try and reach an agreement. Now, we provide a facilitator at no cost to either party. It doesn't cost the school. It doesn't cost the parent. It is not provided for in the law. This is something extra that CERC is paid in our contract through the State Department to assist parties in trying to resolve issues related to children.
And you stated this is not automatic, right, Joanne?
Right, right.
Both parties, someone has to request it initially.
Right, right. It's not provided in the law, so someone will have to ask for it. And it's not uncommon for a school to send us documentation that says, you know, my name is Mark Jones and I represent this school district as their attorney. The school district will be requesting a facilitator for the resolution session. I mean, sometimes they do it right away because they know the parents pro se and it's going to the resolution session and they want a facilitator there. So parents will often, that's one of the reasons CERC will call, is to find out if you want a facilitator. Because we can't just have something, it's hard. It's a quick timeline. If you're in a regular due process, you have 15 days, but it's pretty tight. Our mediators, the people that facilitate these are mediators and they have busy schedules. So we have to find someone that would be able to attend. Okay, so what happens in a resolution session? What's it all about? Well, you're working to settle some or all of the issues. Maybe you can work to settle some of the issues. Maybe you can agree, maybe you've piled on several issues and you can agree on several of them, but there's one you can't agree on that needs to go on to hearing. So you would settle in the resolution agreement those things that you could settle. We always hope that people settle because, and the reason is, I never hear from happy people about the process. Schools are unhappy about having to go through the process. It's not a fun experience for parents. It's difficult to get through this. It's emotionally draining. It takes a lot of your time on both sides. And so we hear the people's pain. And we know that if we can arrange settlement, keep the focus on the child without having to put all of the people through this, that it's probably better for that child. However, there are some issues that may be legal based and need to go to hearing. They need to go, and we understand that. So we're not discouraging due process. We just want to try to make sure that we're giving all options for settlement before you go through the hearing. Also, with any kind of alternative dispute resolution, like a resolution session, the outcome of how it's settled is kept in the hands of the parties. So in this case, for instance, if I'm talking to parents, parents will have a say in what might resolve their complaint. Because if it goes to hearing, the hearing officer is going to make decisions. They're going to have those legal standards. They're going to take the evidence and they're going to weigh it against the legal standard. And it's either, in their opinion, where they find it's going to meet the standard or it doesn't. And the parent may be unhappy with that decision. The school may be unhappy with that decision. And then the hearing officer crafts what is the remedy that those parties will, that child will receive. And sometimes the parent's not happy about that. And hearing officers will frequently tell the parties, it's always better if you can settle this yourself because you may not like what I did. And so if you go to that resolution session and it doesn't settle on the first day, that's okay. It's important that you keep trying to settle. If you can, if you are done with settlement, maybe you go to the resolution session and 3 days later you think, maybe I was unreasonable. It wouldn't be so bad if Ms. Jones came to be the new para, and maybe that's okay. And maybe you write back and say, I was thinking that it would probably be okay to switch and use this other person, and that would be all right to resolve. It's not exactly what I want, but it could resolve it. So you would keep negotiating. I'm just giving you an example, a little something I just threw out there.
And Joanne?
Yes.
Those negotiations, the continued negotiations during the resolution time period, does not necessarily mean there has to be another formal session. It could just be negotiations between the school or their legal representation and the parent or their legal representation, where it's
Right,
just like
right.
the attorney court system would negotiate certain
It could
agreements.
be. It could done through a series of emails, but it really should end in an agreement that's signed by everybody. They would send you a resolution agreement that you would need to sign, because every resolution has to be signed and in writing and enforceable. But you could still continue to negotiate. If the parties go to resolution session and they both say, that's it, we're done, we are drawn in the line, there is no use to doing this anymore, they can ask the hearing officer, they can tell the hearing officer where they're at and ask for the timeline to begin, to jump up that week or two and start the hearing, maybe 3 weeks. I've never seen that happen. And again, I think that's because preparing for hearing takes a while. Parents have to gather all the documentation. They have to talk to the people who are going to testify on their behalf. Maybe they have to contact doctors. Maybe they have to get evaluations that they've had before. They have to gather all the information they need from the school, and it takes time. It can't always be done within 15 days. You might be a parent that has it ahead of time. That's great, but a lot of people don't. Schools, on the other hand, when they have a due process filed against them, the attorney comes down and they have to have a series of meetings within the school. And the attorney comes down, they interview people, they find out what the legal issues are. I mean, they have a process they go through to gather. They have to make the same evidence, get everything ready. And it's something, it can be done in a short amount of time, but it's very difficult. So we don't generally see, I don't think I've ever in my 18 years seen anybody say, we're done, we want to go straight to hearing.
Well, and even if people are prepared in terms of their exhibits and all the things they need to have ready, it's like you said earlier, and I think maybe you and Sharon from Oklahoma Parent Center had mentioned this in the first webinar, they've lost the control when you go to hearing, and you may end up with a decision that you're not happy with, school or parent. When I think you and Sharon had talked about, sometimes when the two parties can negotiate prior, you may end up with something beyond what's legally required. Sometimes schools will give extra because they realize, oh, we're willing to provide this thing, but it's more than FAPE, which
Right.
wouldn't typically happen if the hearing officer is having to make just the decision based upon legal precedent.
Yeah, and you make a really good point there, because FAPE in general is defined as an IEP reasonably in Oklahoma, an IEP reasonably calculated at the time it is written to provide some educational benefit in light of the child's individual circumstance. So it's not a bright line, and it's really not a high bar. I think that's one thing I noticed when I began reading cases years ago, is that there's many cases where the court said, we understand you want the very best for your child's parent, but the school doesn't have to provide maximum benefit to your child. They have to provide enough that your child is making educational progress. And so that's what the hearing officer is weighing. How much progress did the child make? What areas was the child doing? And they may see that it may be their opinion the child has made sufficient progress. And maybe the school is offering more than they have to. Because honestly, I was a teacher for 15 plus years. There was not a day I woke up, nor did I know any other teacher that woke up and said, what is the least amount we can offer this child today so that we're meeting this legal standard, but not having to do too much work? I mean, mostly schools are trying to get kids to learn as much as they can. Not every program is perfect, but many schools provide more than FAPE in a lot of ways. And I think it shows in our due process requests that, we have over 100,000 kids in special education. We don't have anywhere near, not even 1% of 100,000 cases. Okay, so the timeline's different in an expedited due process. So an expedited due process is only for limited issues. Sometimes parents file on the expedited form because they think my case is important and I want it heard fast. That's not the standard for expedited. Expedited due processes concern a disagreement with a manifestation determination or the process of the manifestation determination, or if they disagree with the interim placement of the child's suspension. Like they'll say, your child is suspended and this is going to be their educational program during that suspension. If the parent disagrees with that, they can file for an expedited due process. And again, it's expedited because this involves a child's removal from school. And the federal government, OSEP, the law wants as much attention to be given to this. And we want to limit the amount if if the child was unfairly removed. So this resolution session, I'm going to say 15 days. That's what it is. It's 15 days. The due process hearing can't start before 15 days, calendar days. And the resolution session is set within 7 calendar days. That's fast. That means you file on a Thursday, they have to have that resolution session by Thursday of the next week. So it's fast. And then after this 15 days, you have to be ready to start in the hearing. I didn't go into it but remember the expedited due process the hearing takes place within 20 school days. So you only have a short period of time to get ready for that hearing. Now, these are not as complicated hearings as far as lots of documents. Generally because they're just about a specific issue of the child's disability or what happened around whether this was a direct and substantial cause of the disability or the interim placement. And again, this resolution session is attended by parents and relevant members of the IEP team and a school district personnel that can bind the decision of the school district. They can sign off on the contract as a legal representation because school is like a corporation. It's an entity, and they have to have somebody authorized to sign off on that agreement. Again, parents and schools get to decide who those people are. The parent can't choose who comes for the school, and the school can't choose who comes for the parent. So the parent could bring an attorney. The parent doesn't have to bring an attorney. If the school does not bring an attorney, the school cannot. If the parent does not bring an attorney, the school cannot bring an attorney. This is only in resolution sessions. Sometimes we hear that from parents. They get confused and they're like, why is the school attorney contacting me? And I'm like, well, you initiated a legal case and the person you're going to be negotiating with is the school attorney. And if I don't have an attorney, they can't contact me. No, that's not correct. It's only during these resolution sessions. If you don't have an attorney, the school can't bring their attorney to the resolution session. Any other times, it's going to be appropriate that the school attorney contact you, unless you're represented by counsel, and then they will only contact the represented counsel. Issues that are resolved in this resolution session will be signed by the parties. They are enforceable in court, and the party can rescind within 3 business days. So they will often say, are you satisfied with this due process? Do you want to withdraw the due process? If they have settled everything, the parent may say yes, and they tell the hearing officer that it has resolved, but the hearing officer will still have to wait 3 business days before they can dismiss the case.
So the concept of these resolution sessions, Joanne, for a regular due process filing versus expedited, the way the sessions work are pretty much identical, other than the timeline requirements of the period when the sessions have to occur, things like that. But the way they function and what happens in them is very much the same.
Right, exactly. So what else happens during that resolution time period? Parents file, and I think sometimes they take a sigh of relief. Oh, it's done. Oh, it isn't done. It's just beginning. Because during that 30 days, you have to continue to prepare for the hearing. There's not much else you can do. You have to continue on and keep your eye on the ball. If it settles, great. If it doesn't, you need to be prepared. The hearing officer will contact the party during this resolution time period, that 30 days or the 15 days. They're going to contact them with two pre-hearing conferences. They are pre-hearing conferences. Hearing officers may refer to them as different things. That initial pre-hearing conference ends in a prepared scheduling order, which means the hearing officer is scheduling the parties to do certain things by certain dates. And sometimes they will call that a scheduling conference, but it's still an initial. It's the first one of the two that will occur. Sometimes more occur if issues come up and the parties want the hearing officer to talk to them about it, they can ask for for another conference to discuss a problem. But generally there are these two. In the initial conference, the hearing officer is going to talk to you about what the case is about. They're going to talk to you about the person filing the case has the burden of proof. And they're going to talk about if you need subpoenas, you're going to have to get those subpoenas signed by the hearing officer no later than 10 calendar days before the hearing. They actually should be signed by the hearing officer before that and as soon as possible, because even though the hearing officer signs it, you've got to get it to that person. So maybe you're doing a parent may be doing a subpoena for a doctor. Sometimes people want them for their work. And if they get a subpoena, then their work will let them off work. The parent has to arrange to pay for someone to come as an expert witness. They have to pay for their own expert witnesses. And this is generally not reimbursed. It's one of the sad things I have to say. Early in my career, expert witnesses were reimbursed with attorney fees, but there were some court cases that came about that ceased that practice. I don't know if there's a new case that maybe allowed that practice, but I don't think so. Then the hearing officer will come out after that first initial conference with something called a scheduling order. And they're going to give you certain dates, what you have to do by certain times. They're going to talk to the parties. Are there anything coming up? They'll ask about any motions that the school district might file, because the school district can file legal motions during this time. And the second pre-hearing conference usually comes after you've had your resolution session or mediation, but prior to the hearing, where they're going to go over any issues that have come up. Maybe a parent says, I've been trying to get this documentation from the school and they're not sending it to me. I want so-and-so to testify, but the school hasn't responded if they are still employed there. Because remember, if the person you're calling to testify is employed by the school district, then the school district must present them. If they are not, if the school district does not have control over that person, you will have to subpoena them. If you don't know, generally you can ask the school district attorney. We have an expectation that parties will be polite to each other. And if you make that request of the school district, will I have to issue subpoenas for these people? And you name them off, they will say no, 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 yes. And they can tell you who you can and who they will present. The one thing that throws some parents off is this lack of sufficiency motion, and it's found in the regulations at 34 CFR 300-508 Section D. And in the regulations, they state that the hearing request from the parent will be deemed sufficient to move to hearing unless the school district files a lack of sufficiency motion within a certain amount of time. And so that lack of sufficiency motion says the parent has filed this motion, but it does not give us enough information to know how we violated the law. So remember in the first webinar, I talked about how important it was for you to understand that how they violated the law and facts. Like I've heard hearing officers say to parents, there should be at least a set of facts that led you to believe the school had violated your child's rights. So let's say, I'm just going to make this up off the top of my head. The parent is saying, I've never been invited to a meeting ever. And they put in there, I received my child's documents. It showed that IEP meetings were held on October 1st, November 30th, and February 2nd, but I received no notice of meeting, no contact. The school met without me, and I was never notified. Then that would be your claim of the violation. The school district's job then is to say how you were notified. If you weren't notified, they'll probably be starting to settle with you. I mean, that's just kind of the way it goes. But in that lack of sufficiency motion, if you didn't give those facts, if you just said something like, I'm not invited to meetings, that alone doesn't say anything. That's just a claim, but there's no facts. There's no nothing like what meeting, what are you talking about? So in that lack of sufficiency motion, federal law is very specific. When the school district files it, this hearing officer has 5 calendar days to review over the pleadings, and off the face of the pleadings, just by reading that due process complaint, is it sufficient to state a claim? If it is sufficient, the hearing officer will say that. If it's not sufficient to some claims, the hearing officer will say that. If you need to amend, the hearing officer is required to tell you why your due process hearing request or complaint notice was not sufficient and what you can do to correct it, like additional facts, different this, and then they will send that to you. Generally, with a lack of sufficiency motion, when they have a pro se parent, they could dismiss the case. And I have seen that happen in some varieties. Oftentimes, they will give the parent a week or 2 weeks to amend that complaint before dismissing it. Sometimes when that lack of sufficiency motion is made, maybe a parent realizes that what they wrote in their due process complaint does not allege a violation of the law. Maybe a light bulb goes off. Maybe the parent was saying that they have not addressed my child, they're not identifying my child as autistic, but the records show that the child was found to be autistic as a category, that the autism was addressed in goals, that the issues of the autism were addressed with therapy. So maybe they realized that, oh, well, it has been, I just didn't know, I'm confused. Sometimes we see parents, not always, but sometimes, that when that lack of sufficiency motion, when the hearing officer finds that it's not sufficient and gives that parent time to amend, sometimes a parent amends, but sometimes they do not. And if they don't amend by the date the hearing officer gives them, the hearing officer will dismiss it. Okay, I just want to give you a real quick recap before I go a little bit into evidence. But just as a recap over the resolution time period, there's 2 different lines of activities going on. You're trying to resolve the issues before you go to hearing, but you're also preparing to get ready for that hearing, and you're also dealing with some legal issues along the way. So there's kind of 2 lines. You're getting ready for the hearing, dealing with legal motions or issues, and you're trying to resolve the hearing. Okay, next slide. As you're preparing for hearing, this is kind of what you're doing, and I'll probably go into a little bit more detail in the next webinar, but generally you're preparing your documents. You have to, if you have filed the due process, whoever files it has the burden of proof. They have to prove their case. And so they get their evidence ready. And there has to be 4 identical copies of all the evidence. We require, suggest, I don't think your case is going to be dismissed for it, but it's going to be really helpful if you get a notebook. And you may have to have more than 1 notebook. It's not uncommon for us to see 4 or 5 notebooks, but you hole punch those documents, you put them in the notebook, and you get your evidence together. Each piece of evidence is listed in a list and it's numbered. So let's say the parent's evidence book, the documents you might open and number evidence number 1, parent exhibit 1. You could have a little tab on there that you buy, a cheaper tab that you write with a Sharpie on there, 1. And then on the document, you list parent PE1, like parent exhibit 1. And maybe the name of it is prior written notice of July 31st, 2020. So it has a date, like it's what is it and what date is it? What is this document? It could be it's an evaluation done, a private evaluation by Dr. Jones from July of 2021. So whatever the name of it is, you specifically put on there. If it's an email from parent to teacher, email from teacher to parent, this date, that kind of thing. And everything is documented. That, and these evidence pieces are things that you would be submitting to prove your case. Notebooks make it very helpful. I tell parents the best thing is really to create 1 notebook, 1 set of evidence, and then replicate it with 3 additional copies. They have to be identical. And the reason is 1 of the notebooks goes to the witness. Think of it as a little trial, and there's a judge, there's a witness, a court reporter, and the 2 sides. So the school district has a copy, you have a copy, the judge has a copy, and the witness has a copy. And when you get up to talk about your case, you may say, look in exhibit notebook number 1, turn to parent exhibit 15. This is an IEP. Please turn to page 7 of that IEP. Well, that's so that everybody can be on the same page of what it is you want to talk about. Maybe you want to talk about the placement of the child. You would give the page number of the IEP where it talks about placement. Maybe you want to talk about goals. Maybe you want to talk about the section, I always call it the plat, the levels of performance of the child. Yes, the levels of performance. And so you might say, this is the IEP, turn to page 2 of this IEP. So you want to get everybody zeroed in on the same evidence. And the only way to do that in any coordinated way is to have these copies. Unfortunately, this is something that can be expensive. If we have additional notebooks that are laying around, you can always ask us. Sometimes when we archive documents, we have to take things out of notebooks. So occasionally we have some notebooks in our office. We can tell you cheap ways to make tabs. You can buy file folder labels and fold them over, cut them in half and fold them over and make your tabs. We can tell you kind of cheap ways to do things. You could go to the office supply store and buy these prepared numbered exhibits, and they're very expensive. They're like $20 a set, and they, go up to like 200. And you have to buy 1 through 25, 25 through 50, or 26 through 50, 51 through 75, 76 through 100, like that. And they are expensive, but you can make your own cheaper.
Now, like Joanne, thinking in terms of, if we have the extra supplies, we can certainly help provide them and give tips. But our agency and the OSDE or any others related to this process, we don't have funding to pay for this stuff for either parents or schools for them to come. We just don't have the money to do
and
that
this is sometimes why we hear parents complain it's unfair, because it's expensive sometimes. If you've got 200 exhibits. It's expensive to copy 4 copies of 200 exhibits. I understand. But our agency is not funded to provide those copies to you. The law assumes that you will prepare those, pay for that. And if you win and go to court and get your fees reimbursed, your fees and expenses, those costs would be listed there. So if we happen to have some, I'm just saying we could share them with you, but we do not provide notebooks. We're not obligated to provide them. I want to be real clear about that. We just understand because parents call us and they're like, do you know how much this is going to cost? And we're like, yes, we are aware of that. But that is part of the expense that a parent has. The other thing a parent has to provide is subpoenas for persons who are not employed by the school. And so sometimes, I mean, you're going to have to find out if they have a related service provider. The school may have control over them or may not. So that's someone you're going to have to ask about. If it's a teacher from 2 years ago and that teacher is no longer there, the school has no authority over them and you would have to find them, locate them, and subpoena them on your own. We have copies of what a subpoena looks like in the special education due process guidelines. There's one for the subpoena of persons, and there's one for subpoena of documents. The legal term for the documents is a subpoena ducus tecum, and that means you're subpoenaing documents. You should be able to just request your documents from the school, and the hearing officer will urge them to provide it because you have to have those documents. But those subpoenas, whether it's for a subpoena ducus tecum or whether it's to a person to testify, maybe you're asking an outside provider, maybe you're asking for a teacher that no longer is employed by the school, maybe a related service provider, you would have to ask the hearing officer to sign off on that subpoena and serve it. And the hearing official, just so you know, if that person refuses to sign up, our hearing officer does not have what we call in law contempt authority. So if you wanted to enforce that person to show up at the hearing, you have to go to district court to enforce that. Now, it's not really come up. Most of the time, it's not been a problem. I think back in the past, and I think once or twice, we had a problem with, maybe I can just remember a case. I don't know if it was one I did or one when I was at CERT, but where there was problems getting people to show up. But generally, the school will cooperate with you in getting the people there. Prior to the hearing, they will ask you to tell them the order in which you're going to have witnesses show up. And sometimes I think people's natural thing is, I want to catch them off guard. I'm not going to tell them what order. Well, we ask you to be polite and just say, we think we're going to call the math teacher first, the reading teacher second. It's just the polite thing to do. We want everyone to be polite, and the school will have them available or close so that they can be called. It doesn't make any sense for a school to take 20 employees and have them sit in a room waiting for their turn to testify if they may not testify till late in the day. That's a lot of time out of the classroom for other students. So we want to be cooperative there. Do you have any questions, Allison?
I don't think so.
Okay, now I will say that
all of this. Sorry.
Preparing that list of those evidence, the exhibit list is a list of each one of those documents. And it would say parent exhibit 1, and it might say IEP of 12/25/2019. The second one, prior written notice dated February 2nd, 2020. I mean, it would be specific things on those exhibits. And then that exhibit list must be given to the school 7 calendar days at no later than 7 calendar days prior to the hearing, or They often call it 5 business days is really how the regs talk about it. 5 business days prior to the hearing. And I probably should have put that on there because maybe with holidays that would make a difference. The witness list is the same, and you would list off anyone you think you're going to call to testify about your case. And you would list off who they are, their address. Now, if they are an employee of the school, you would just say, I live in Tulsa, so I'm going to use Tulsa Public Schools. So it would say, Mrs. Jones, Tulsa Public Schools, and then you would tell what they're going to testify to. And it's just general. It's like the child's educational performance or how he does in class or about the testing, how she graded, or, something that you're going to say what they're going to testify to, just so the hearing officer can determine their relevancy. And if they're not employed, you do have to get a subpoena from the hearing officer. And the school may know where they have moved. Maybe they're no longer employed by that district, but the school knows where they are. If they don't, well, you're going to have to find out where they went or what their home address was, or it'll be up to you to present them at the hearing. But if they are currently employed by the school and under the control of the school will present them. And all of these things will be given to you from the school. Now, so the reason this whole webinar, I keep talking as if it's parents filing, is because most school districts are represented by attorneys. They already know this. They do it all the time. We hear a lot, and OSEP is concerned, and our state is concerned. What assistance are we giving parents? We can't do it for you, but we can try to explain the mystery of the rules. And that's what we're trying to do here. So I'm kind of focusing on what it would look like if it was a parent. Okay, next slide.
Joanne, I think the crux, like we mentioned in the first webinar, is not necessarily that we're trying to say, don't do this, but we're trying to say, be fully informed so that you know what you're walking into.
Exactly.
That it is overwhelming. It's a lot. You're filing a legal filing. So it starts this big legal process that can be very overwhelming. And sometimes, a lot of times, I know we talked about with Sharon in the last one, is, it tends to stem from being mad at the school, and you get mad and then you want to do something about it. But before you do that, take a breath and phone a friend and think about, are these really the issues? Is it worth due process? And which ones really can you file due process on, or are able to be ruled on by a hearing officer under these regulations?
Right. And we can say that because I heard the pain, and I know Allison hears it now, when parents file and then they call and they're like, I don't know what I'm doing. What do I do next? I don't know what to do. And we're just saying that before you do, it's really best if you can be fully informed. If you have a child and you want to learn about procedural safeguards, if you think it's ever going to happen, you should at least understand the process and take the time to learn. Here is the Special Education Resolution Center. We're part of OSU. We have a contract with the State Department of Education. They are here. I'm no longer there. If I say we, it's because I am retired. I am just helping out to give some information for the center. This is the CERC website, the address, the phone number for the local 918, and the toll-free number if you need to call and talk to anyone. I don't see any questions in the chat. We'll wait here for just a few minutes.
Doesn't look like that we have any in the Q&A either.
Okay, so what I will say is that Rob we will have these webinars up and archived. It'll take about a week or two to get them, but we hope that they will be there for future reference for people to listen to when they do file due process and they're a little bit confused about what it means, and maybe kind of taking the mystery, a chance to talk about these rules, why they were put in place and what they generally are. Okay, thank you so much for being with us today.
Thank you. And thanks, Joanne.
Thank you for having me.
Thank you. Thank you, ladies, and thank you everyone for attending today.
Thanks, Rob.